of Appeals Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in our case number CV16 0082, Preciado versus Young America Insurance Company. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time if you wish to do so. If you wish to do so, you need to keep track of your own time at the clock on the podium. Out of respect for counsel, I would ask that those in attendance make sure that your cell phones are off so our conversation is not interrupted. We've read the briefs. We are familiar with the record. We've conferenced the case. We'd encourage you to keep that in mind as you present your arguments today. Our proceedings are being recorded and then will be posted to the court's website and YouTube in due course. So that means I would ask that you, when you approach the podium the first time, tell us your name and the party that you represent. So with that, we'll begin with Mr. Onofre.
Charles Onofre, representing Young America, the appellant in this case, Your Honor. This morning I'm asking the court to address two issues, really. We are asking for a new trial, but at the very minimum, we think the entire punitive damage award should be vacated. And the basis of each of those requests is really the same, and it's based on the same three components or elements of the case. The first being the order that was obtained changing the policy language from ACR to retail. It is the misrepresentation of the testimony, the claim that Young America admitted that it paid wholesale on total loss valuations. And it's the admission and use of the consent order. We think each three of those items was a contortion of the evidence, a misrepresentation, or was obtained in a way that was fundamentally unfair. It was clearly, those three items are clearly the basis for their punitive damage claim. You simply have to look at their opening statement, closing argument. That was the punitive claim. And it really was the core claim of bad faith in the case. And we contend, you look at those three items, and it just infects the entire case. And in many respects, and I'll get to it, we're hamstrung so that we can't do anything to effectively respond to it. And that's especially true with the consent order. But here's the punitive theory, and again, the core bad faith theory, that Young America consistently rips off its insureds by paying wholesale on total loss valuations when the law says, because the judge entered the order, the law says they pay retail. And Young America even fooled the Department of Insurance as evidenced by the consent order. That was their theory. That's what the theory that they beat like a drum. And I can tell you that that theory isn't really fundamentally disclosed until about 13 days before trial. But to get into some of the specifics, the first, the order that changes the policy from ACR to retail, there's no law that says that they have to pay retail. The policy says ACV.
Well, didn't Mr. Du Bois concede that at the status conference?
Your Honor, he did. And if I could talk about the circumstances that led up to it. And here we have a telephonic status conference where the only issue is to schedule the trial. I give my first-year associate my trial calendar, and it turns into this discussion on an issue that they represent as completely innocuous.
Well, it's an issue that had been raised or attempted to be raised several times before.
He indicated that he wanted to brief out that issue. True. But there's a difference between saying you want to raise the issue and saying it's a little point and then it ended up being the cornerstone of your case, which is what it was in the opening and closing. And
had the adjuster's deposition been taken at that point?
Sorry, at which point?
Saldano, was that his name?
Arturo Saldano.
Had his deposition been taken by the time of that status conference?
The answer is yes. I think at least 6 months, maybe even upwards of a year before. I think it was in March 14, and the conference was in January 15. And so this is after, I'll say, working over Mr. Du Bois, who does not appreciate, because there hasn't been a disclosure by the plaintiff as to exactly how they're going to use it. And again, the preamble to all that is, well, this is just a little thing. And it turns out not to be a little thing at all. Of course, we don't know that really until April 21 when the argument comes on for the punitive damage claim. But the manner in which that order was obtained was certainly not one in which there was full candor about why he wanted it and how it was going to be used. And Mr. Dubois did initially say, we object to that. And I don't think the court can disregard it. It is a telephonic trial setting conference where no issue was supposed to be addressed at all other than setting the trial.
Well, I guess my question, and obviously this is retrospective on my part, but it seems to me that this whole issue of retail versus wholesale was set up or created at that moment in the adjuster's deposition. And perhaps the insurer didn't appreciate what was happening at that point.
Well, there certainly was a question whether or not, what is it that he pays? And the answer, of course, is it's actual cash value. Then there's the debate back and forth. But exactly how he's going to work that into a violation of the law, and that's how he uses it. When you look at the opening statement and the cross-examination, in the opening, he talks about how important it is that the judge's ruling is on this. The court's ruled. Now, this is an important ruling, as you'll see, as the evidence unfolds in the case. The difference dollar-wise in terms of whether you use retail or ACV or auction, that's meaningless in the scheme of things. The importance in how getting that order and how he used it is to say, this is the law, and they knowingly violate it. And so when you combine that, how he got the order, with the way he used the testimony from the claims handler, when he takes the deposition of the claims handler, no way do we believe he's ever going to get up in front of the jury and say, Mr. Saldano, who works for Fred Loya, who never worked for Young America, admits for Young America that they pay wholesale. Why would we ever expect that? He doesn't even work for Young America. He never saw the NADA report. So until we know how he's going to misrepresent that testimony, the obtaining of that order, while less than candid, we don't understand or appreciate the full scope of how he's going to use that by combining it with the misrepresentation of Mr. Saldano's testimony, and why he would ever believe that he could represent that Young America made that concession through the testimony of a witness who never worked for Young America, who never saw this NADA report.
Didn't the, if I'm remembering the status conference correctly, it seemed to me that the court, after obtaining that concession as to what actual cash value meant, that it meant retail market value, it seems like the court then also gave the parties full discretion to argue its position as to what retail value meant. So
the court may have, but again, the importance is not in which you should apply and the dollar difference it results in. It's his ability to get up and say, the law says, the judge ordered, and then taking Mr. Saldano's testimony and saying that he admitted that Young America pays wholesale. That's an admission. I mean, he keeps repeating that misrepresentation throughout the entire case.
Did Mr. Saldano correct his deposition in any fashion?
He answered the questions directly in terms of, who do you work for? Fred Loya. Did you see the NADA report? No, I didn't.
That's not what I'm asking. I'm asking, did he change his test or attempt to change his testimony or correct it relative to that answer?
The answer is no, because when you read the deposition, as we read it, he's correct in how he answers the questions. You have to really appreciate how the questioning is manipulated in the deposition. And if you read in the trial transcript in particular, I'll remember the page a little bit later. It's pages 139 to 146. It's either the second or third day of trial. That's the colloquy that goes back and forth. You will see what he says is the basis for him claiming they admitted that they pay wholesale. And again, this is a person who works for Young America. There had to have been a contortion because he would have no basis to make that admission, and he didn't see the NADA report. So we think there was less than full candor in obtaining that order and how you got it and how you're going to use it, number one. Then we have the misrepresentation of Mr. Saldanis.
Counsel, with respect to the candor about how they were going to use it, what are you claiming they should have told the trial court either before the order or before trial or at trial? I mean, a trial
Sure.
has surprises on occasion.
Absolutely, and I think that you have to introduce the third component, which is the consent order. And they disclosed the consent order less than 60 days before trial. I look at that and say, well, what's this got to do with anything? The relevance is you can't say when you look at that you know it's relevant to the issues in the case. It's only when we get to the argument on the summary judgment motion, which is April 21, that they put the pieces of the puzzle together. Now, I get that there's always some unknown going to trial. But when that's your cornerstone of your case, and it was, you can't read the opening statement and the closing argument without realizing that's their cornerstone argument. How we get that dumped on us on April 21 by pulling it all together. Because he's not telling us when he gets the order, he's not telling us that he's going to misrepresent Mr. Saldana's testimony. And we don't have the consent order. We have it, but we don't know what part he says is relevant until April 21. We get there. So I have 13 days, once this is disclosed, to respond to the consent order. I can't do any discovery, any disclosure. I'm stuck with that. And just imagine the impact on the jury when that consent order comes in. It's from the Department of Insurance. We get sanctioned. We get a penalty. He's willing to say, oh, those 56 of the 111 files that were audited, they pulled or withheld the total loss valuations, just like they did here. He's willing to say that. It doesn't say that, but he's willing to say that that's what it represents. I can't say anything. Here's my choice in closing. I either ignore it or I say, oh, it doesn't say that. And you know every single juror would be saying, well, why don't you prove it? And the answer is, what, in 10 days?
Well,
12 days?
counsel, the consent order obviously was not a surprise to your client. It was a signatory to the order.
Correct, but the importance, Judge, is how would...
Do you not think that that was something you should have disclosed during litigation?
Number one, no. And number two, I can't even tell why it's relevant. I mean, to think that that paragraph about some files missed some claim file, 56 of the 111 audited files had some claim file missing. All right? Who knows what document they're referring to? And even assuming that it should have been disclosed, we need at least an opportunity to know it's going to be used so that we can look at those files and try and come up with a defense. And in retrospect, in the motion for a new trial, we attached some documents to show what we would have developed. And what we didn't appreciate before trial is the fact that this was a business decision by Young America. They purchased by Fred Loy. They purchased Young America. There's this third-party administrator that operates the software. They have shut the Young America system down. So when Loya takes over, they simply extract those file documents that they think are most important, and the system is shut down. Loya can't access it. That's what I would have been able to develop had I known this is going to be used, and it's going to be used in that manner.
You know, counsel, I want to be aware of the time limitations you have here. I'd really like to ask you to shift, if you could, to sort of the basic question about punitive damages. And I'd like you to comment on whether that claim should have gone to the jury at all, particularly in light of this court's decision in Sobieski.
Well, certainly that's our primary point. Once you acknowledge the obvious, Mr. Saldano never made that admission. He can't make that admission. He's not competent to make that admission. It's just a misrepresentation. So,
are you saying he's not authorized to provide evidence that there's a company-wide procedure to place profit ahead of the insured's interests?
well, not only he certainly couldn't speak on behalf of Young America. He didn't work for them at any time. He had worked for Fred Loya. He wasn't present at the time. And the question, I don't recall the question about profit motive even being raised to him, but he certainly didn't address it, and I don't know offhand whether he would even be competent to address it. But for a punitive claim to stand, there has to be obviously proof of evil motive, evil mind. What they have here is, at best, bad claims handling. And all after Fred Loya purchases Young America. It all occurs after that. Young America made an offer within 30 days after it completed its investigation. After that, Fred Loya has purchased the company. That's not Young America hired Fred Loya to run the claims out, where there might be vicarious liability. They got purchased. They made the decision not to sue Fred Loya. And again, in terms of there being evil mind, we know that order has been contorted because we know the policy says ACV. We know Mr. Saldano never said that Young America pays wholesale. What he said is Fred Loya pays ACV and not retail. Just because Loya doesn't pay retail doesn't mean Young America pays wholesale. But that was their argument. Then after that, you get simply to the remaining arguments for punitive damages. The claim of deducting salvage value. First two offers did not deduct salvage value. The third one did, and they said, we'll pay you the salvage, you just got to sign the power of attorney. And ultimately, he was given the full salvage value. After the complaint was filed, there was a back and forth, but he gets the full amount of the $11,000. The not providing the documentation, counsel is incorrect. He repeatedly said that the request was for the report. Now, when you look at page 1888, second or third day of testimony, what was requested was a copy of the settlement offer, all right, not the documentation. And besides, they didn't have access to it, again, because of CSC shutting down the software. Placing the full and final settlement reference on the check, that's nothing other than that's what insurance companies do. It was never used as a way to say, aha, we got you. And I know that because the case was in litigation by that point in time. And if you compare trial exhibits 11 and 12, you will see that he knew this was a replacement check for what was represented as the undisputed portion. Not tendering the undisputed portion, he cites Borland. Borland doesn't say that. Borland vacated the punitive damage award. And the delay in investigating and settling the claim, whether it's Borland, Fulaski, or Farr, just a delay is not basis for punitive damages. You need evil mind. And when you look at the fact that Fred Loya takes over, there's an attempt to transfer the file and copy the file, and then the system shut down. I think you look at that and you combine it with maybe inexperience. Do you get some errors? Sure, you get some errors, but that's a world's difference from evil mind.
Counsel, didn't, though, all these errors cut to the insurance company's benefit?
In what way, Your Honor? Just that by not getting the amount to the insured?
Well, tell me an error that was, you would think if this was explained just by errors, that some errors would favor the insured and some would favor the insurance company. I'm trying to think of one, other than perhaps the $300 payment that you note on appeal, that favored the insured. It seemed like all of these things that you're talking about.
Well, there's certainly errors in claim handling. And is the court wondering if the compilation of the errors would be sufficient to infer evil mind?
The question's different. It seems to me if the claim is that, gosh, this was just a series of, at best, errors, the errors would, if they truly were errors, would go one way and the other, as opposed to always favoring the insurance company.
Well, if I could address the offer that is made, we have an instance where the plaintiff doesn't even respond to the offer. Certainly, the company can't be faulted for the plaintiff not responding.
No, but you're not asserting that's an error either on behalf of your client.
No, certainly not. But it certainly gives The reference that they didn't extend the undisputed portion is in the context of they made an offer and there was no response. I think there was a 4-month gap between making the offer and when the first phone call comes in July. And by that time, Mr. Arnett is already behind the scenes running things. I'm obviously out of time.
Let me ask one other question, if I could. I mean, there's a suggestion here that the insurance company knew Mr. Preciado was in very desperate financial situation and therefore intentionally lowballed him on the offer. What's your response to that?
Well, I can't deny that they knew his finances. That was part of the fraud investigation. So that's a fact. The fact that the court refers to it being lowballed, they made an offer and there was never a contrary piece of evidence ever offered, even through trial, about what the real value was. That Blue Book statement that was admitted at trial, I don't see how that's even evidence. Thank you.
Thank you. Counsel, what we're going to do is, and I'll reserve this for your rebuttal, but we'll give each side 5 additional minutes to allow appellee and additional time and allow appellant some rebuttal time. So bear with us just for a minute while our good bailiff clarifies the clock, and we'll kind of go from there.
Of course, that doesn't mean you have to use all that time.
We probably will, though.
Very well.
Just because we can, I suppose.
Mr.
Good
Arnett.
morning. My name is Wayne Arnett. With me at council table is my brother and law partner, Mark Arnett, and we represent Alejandro Preciado in this case against his insurance company, Young America. Mr. Onofre said something in his brief multiple times. He said it again here today that makes no sense whatsoever. And it's not the law in Arizona, and if that needs some clarification, maybe this is the case to clarify it. When an insurance company owes a duty of good faith and fair dealing, which they all do, they can delegate that responsibility to whoever they want. In other words, Young America is an entity. It is an insurance company. It's a corporation that has shareholders, and it issues policies, and they can choose who they want to handle their claims. In this case, about most of the way through the Mr. Preciado's claim, the corporation was sold. It got new shareholders. The corporation then decided to have Fred Loya handle the claims from that point forward. They can have whoever they want handle the claims. They can have a third-party person. They can have their own employees do it. But under the law, they are responsible. The insurance company is responsible for the acts of their employees and their agents, like Fred Loya, for handling the claim. And in their brief, they said a number of times, well, no, we're not responsible. Young America is not responsible for what Fred Loya did. No citation to any authority. That's not the law. And I cited the cases that say you can delegate however you want, but it's a non-delegable duty in the sense that you are responsible for their conduct. So I just want to lay to rest, I think, that argument that they're not responsible for what Fred Loya did. They are. Fred Loya is Young America. They are the company that handled the claim beginning in May of 2012 after Fred Loya owned it. Before that, it was apparently, at least according to the evidence at trial, it was handled by Young America in their in-house office on the East Coast. Another thing that was said here that is just flat wrong, and that is, oh, well, we lost some of the file, or yeah, those were, we weren't able to get the documents from the COVIS file. There was a computer system that scanned these. It was called COVIS. The evidence at trial was crystal clear that those documents came over. They didn't get lost. In fact, Mr. Saldana testified, I could look at them right now if I just had the passwords. We have those documents. And we were able to demonstrate that some of the documents that were in that COVIS file came into the Fred Loya file. They got the examination under oath from that file. They got copies of photos from that file. And even Mr. Saldana made a note in his file, in the Fred Loya file, saying, I looked at the COVA system and I didn't find the title to the car. Okay? And now there's no way a jury or any fact finder could reach any other conclusion but that they had access to that file. And everybody agrees that the NADA printout that would have told us that this company pays wholesale, not retail, would have been in that file. Now, they've gone to extraordinary extents, in this case, to keep us from seeing that NADA printout. They refused to provide it. They claimed, we lost some part of the file when we know they didn't. We know they had access to it. They even emailed a copy of the NADA printout to Mr. Matheson, who was the lawyer they hired early on in the case to do the examination under oath. We have a copy of that email that says attached is the NADA printout. And I made a formal subpoena to Mr. Matheson for copies of his file, including emails and attachments. And rather than giving them to me, like the subpoena required him to do, he sent them to defense counsel. And by the time they got to me, that NADA printout was not there. All this was presented to the jury. So they went to extraordinary effort to try to keep us from learning the truth, which is we don't pay retail, we pay the wholesale amount. Now, when I took the deposition of Mr. Preciado, and you're right, I took that before any of these conference calls, before this thing about the consent order came up, I asked him at deposition, and I'm reading.
Counsel, I think there's a...
Oh, I'm sorry.
Oh, no, you said Mr. Preciado. You meant Mr. Saldana, right?
I did. I'm sorry. Two Hispanic names, and I mixed them up. Thank you for that clarification. When I took Mr. Saldana's deposition, and I read this to him during the trial to tell the jury exactly what he told us, I said, and it came up in the context of him telling me he had not seen the NADA printout, and I said, well, if we could see it, would we expect it to have the wholesale value or the retail value on it? And he said, I don't know how NADA works. I don't even see wholesale or retail, the difference between the two. And then he changed that and he said, I take that back. I do see the difference. But we would go with the value of the vehicle, not the retail. And then I clarified. I said, so you would be looking at the wholesale value, not the retail value? And then Mr. Saldana said, that's what it would be. Now, I know Mr. Onofre didn't like that testimony. I know Young America didn't like the idea that Mr. Saldana told the truth, that they only pay wholesale, and that if he had his hands on that document that they've tried so hard to keep us from seeing, it would show that it was the wholesale value that they paid. But the jury heard that testimony, and this is an issue of fact. Yes, all of these facts were hotly disputed, and the jury didn't believe that they paid retail like they should, and they believed this testimony where he said that's what it would be. It would be the wholesale amount. So we have. And another point, too, I mean, if this was a misrepresentation, if in my closing argument somehow I misrepresented what Mr. Saldana said, and if memory serves me right, I think I actually read this again to the jury for the part I read to the deposition in the closing argument. But if I did misrepresent it, then it's up to them to point out that fact as part of the give and take on the way trials are given. And if there was an explanation for his testimony, or if he wanted to change that testimony, he could have done that at trial, I suppose, or tried to. They could make that argument. But all that is a classic issue of fact. And even for punitive damages, circumstantial evidence is admissible. We have to prove it by clear and convincing evidence, but We don't have to have a confession that they acted with an evil mind or a confession that the insurance company acted in bad faith, although we came very close to having that in this case, as we pointed out in our brief. I want to point out, too, that I've been doing this a while, and I don't think the disclosure requirements, Rule 26, I don't think it requires me to set forth my opening and closing arguments. I don't think the rules make me set forth exactly how I'm going to use each piece of evidence. What it does require me to do is set forth the factual basis for my claim and set forth the exhibits and witnesses that I'm going to use at trial. But I've never been asked to submit my opening statement and my closing arguments in advance for counsel to see them and to see where I'm going with the evidence. I just don't. I know we don't have as many surprises as we did when I first started practicing law before Rule 26.1, but we do have some surprises.
At some point, you had to tell the court and counsel what the purported relevance was of the consent order.
I'm sorry.
The consent order?
Yes.
What did you disclose about that?
Well, I disclosed the consent order and that I intended to use it as an exhibit at trial, and then, if memory serves me right, I think the consent order came up in the arguments for the motion for summary judgment, which they had made on bad faith and punitive damages. And so, yeah, we set forth our the whole position that this company pays wholesale. We have that testimony from this witness, and we wanted, well, there were several findings. I think there were 9 in the original consent order, and the judge excluded all but 2. And those 2 were that they didn't conclude claims, they didn't conduct their investigation within 30 days, as they are required to do, and the other one was that they didn't keep their files in such a way that you could tell what they did what took place in the claims handling. And we had both of those issues in this case, and that's why they were relevant. But again, like I said, I don't think there's a requirement that I put together all the puzzles of the pieces and say exactly how I'm going to use relevant evidence that's coming into trial in my opening and closing statements. And they didn't object to any of those arguments at trial.
Well, on the face of the consent order, it doesn't reference one way or the other a practice of undervaluing or underpaying insured's claims based on wholesale versus retail.
It doesn't. The 2 points that he left in were only on those 2. Failure to process claim or conclude investigations within 30 days, and not keeping the claim file in such a way that you can tell what they did. And it wasn't just the NADA printout that was the problem with that. There were other things in the file that should have been there. For example, the entry of when they closed the file right after they got it in Texas, they closed it for non-cooperation, and there was an order, there was an entry saying why they did that, but that's now gone. And so we had those issues too that made it relevant.
Since we're talking about the disclosure of the consent order, can I ask you a couple of procedural questions
Yes.
about how this happened? Your office is the one that disclosed the order,
Yes.
correct? But it was within the 60 days before trial.
I believe so.
And so
I don't have those dates clearly.
Okay.
I believe so, yes.
in looking at Rule 37, C4, I know you've got this memorized. The language of that rule seems pretty direct and literal, that when you want to disclose, make that type of disclosure and use an exhibit or piece of evidence within the 60 days, you have to actually bring a motion yourself to do that. But that didn't happen here.
Did not happen here.
And the motion has to be supported by an affidavit. And that didn't happen either.
No, sir.
So what I'm struggling with is a procedural issue where the rule seems to read in literal terms a mandatory language that the party offering it must do it by motion must support it by an affidavit. So help me understand what we should do with that.
I will, and I'll tell you exactly what Judge Udall did faced with that same argument, okay? And it was, this is a document that was no surprise to them, and that's been mentioned here today. They authored it. This was not like a document that I kind of found out there somewhere outside of Young America. This is Young America's document. It's signed by Fred Loya, the only stockholder in Young America. It was their document, and it was them that had an obligation to give it to me during the discovery period, and they learned about it the July before and never disclosed it. And so, although I understand the why we have that rule about disclosing exhibits late and making motions. I understand that, but Judge Udall, looking at this, said I have to make an exception here because it is their document, and it was them that did not disclose it. And it was them that did not file a motion to do it late if they learned about it later. But they didn't learn about it later. They learned about it at the time he signed it. And so I think there has to be some flexibility for trial judges with respect to those rules when it's a document that belongs to them and should have been disclosed.
And I just don't remember this. Was there any request after the court indicated it would allow that exhibit? Was there any request by the defendant to continue the trial or reopen discovery so that they could gather further evidence to rebut the use of the order?
There was sort of. Mr. Dubois, counsel for Young America at the time, said, well, then I'm going to move to continue. He didn't actually move to continue, and he said I'm going to have to do some discovery. And this is in the record. It was part of the transcript. You have the transcript of that hearing, and I don't remember the exact date of it right now. Maybe I can get it in a second. And there was some discussion about it, and the court asked, and I asked, well, what possible discovery could you want to do about a document that is yours? And he said, well, if this is gonna come into evidence, then I want this document to come in that explains it. And I said, and the court agreed, fine, you can do that. And I asked Mr. Dubois this, and which is going to be required for any motion to continue. What discovery do you want? What deposition do you want to take? What documents do you want to subpoena from somebody outside of Young America? And the court and I explained, we're not trying to take advantage of you here. If there's something you want to present now that you've learned this, fine, we'll waive the late disclosure for you too. And they did, and an extra document came into evidence to explain that. So because Mr. Dubois was not able to articulate any discovery that he needed to do, any deposition he wanted to take, or any documents he needed to obtain from any other witness or any other party, or even internally, the judge denied that request.
Okay. And I don't want to monopolize your presentation, Mr. Arnett, but I have two other questions
Yes,
I'd really
of course.
like to talk to you about before you sit down. They both relate to the punitive damage award. There seems to have been not a retrenching, but some development of the case law on punitive damages lately that, and I'm thinking of the Sobieski case that I talked to counsel about. And in looking at that case, I'm wondering, and then comparing it to the facts of this case, how you believe that the evidence presented in this case is sufficient to support the letting the jury consider punitive damages in this matter. Okay,
and I'll just summarize.
That's the first question. I'll get to the second.
Yes, and we'll go to the second one. Let me just summarize briefly. And it's not. And I know when you give a closing argument, and I've I refuse to give closing arguments that are longer than an hour to a jury. I've seen them, the eyes glaze over, and you really can't talk that long. And you can't mention everything that supports your claim in punitive damages. You have to pick one theme, one theory, and kind of present it the best you can. But we presented a lot of evidence here on a lot of different things that this company did that demonstrates their evil mind and company practice. The first is their refusal to even give us a copy of the policy. And I've never tried a case when I didn't have a copy of the policy in an insurance bad faith case. And I requested it. Mr. Saldana said in his testimony at his deposition that he would print off the 4 endorsements to this policy and send them to counsel and give them to me. That didn't happen. I have one page of page 1 of a 2-page deck page from the time period before this loss occurred. I don't have a copy of the complete policy. And that's important because we say, well, yeah, this was actual cash value policy, probably, but not necessarily. I had a policy on a 48 Chevy pickup truck that I had that is a stated value policy, and it had a certain amount of money that would get paid if that thing got lost or totaled or destroyed. The policy I have now with USAA pays ACV plus 10%. They vary, and they vary by endorsement. And I don't have these endorsements. Those were kept from us in this case. The fraud investigation that went on for months, accusing him of all kinds of things and requiring him to jump through all kinds of hoops. And even after they concluded that it was going to be paid in December, after the examination under oath, they still didn't pay. And I know they said in their briefs, well, we paid within 30 days of when we concluded our investigation, or we offered to pay within 30 days. They didn't. They knew they were going to have to pay the claim in December and didn't make any offer until the following March. The harassing requests for documents is another thing. At the conclusion of the examination under oath, the lawyer who took it wrote to Young America and said, this is going to be we're not going to be able to deny this claim. I don't have a way to show that this wasn't a theft. This is one we're going to have to pay. And even then, though, they said, well, let's make him get some more documents. And there were 3 categories of documents they made him go get. They wanted his cell phone records, which he had to go get from his cell phone company back during the time of the loss. They wanted copies of 4 or 5 checks, and they wanted contact information for 6 people who were with him the last time he saw the vehicle at his sister's place before it was stolen. That took him a little while to get. In the meantime, they threatened to deny his claim if he didn't come up with those things. But more telling is what they did when he did give them. There is nothing in the file to suggest anybody at Young America or their lawyer ever looked at those things. No one contacted those 5 people. No one did anything with the cell phone records. No one analyzed the checks they'd made him go get copies of from the bank. Now, a jury can conclude from that this is pure harassment. It's just, it wasn't necessary for the handling of the claim. And by the way, they'd already made him sign an authorization for them to go get his cell phone records. And so it was just pure harassment. When Fred Loya takes over the case, the first thing they do is close the file. And there's no dispute about this. They didn't tell Mr. Preciado they were closing the file. They didn't even tell Mr. Preciado they'd taken over claims handling. They just let it sit. And he'd been calling the toll-free number, and he wasn't able to reach anybody back from the previous March. And now it's in May when they take over, and by July 3rd, they close the file. Deny the claim, no payment. Closed it for non-cooperation. And I asked Mr. Saldana at the trial, what in the world could he have done to cooperate better? He couldn't think of anything. Is there any support for closing this claim for non-cooperation? No. So to me, that's just absolutely outrageous. And then, of course, we have hiding the NADA printout, which we've gone over before, the COVA system and the email. And, of course, reducing the payment by the salvage amount is another thing. And the evidence in this case is clearly that this truck, by the time it was found on the mountaintop of Mexico, was owned by Young America. And that's in the police report. The police came into evidence in this case. It says when they got the report that it was in Mexico, the police department contacted the registered owner of the truck, and that was Young America. And we know how that happened. They sent him a power of attorney, so that the title could be could be transferred to Young America, and it was. And they owned this vehicle. They had the title to this vehicle, and the reduction to the salvage was just a pure, well, according to Mr. Saldana, it's the company practice. It's the company practice when people don't settle claims with us and don't accept our amount, to take the salvage value, even on a vehicle that they own and that's sitting on a mountaintop surrounded by a drug cartel in Mexico that they can't get. And the last one I want to mention is the jack and the compressor. When he made this claim, he sent over a proof of loss. And this policy, if the policy we have is like, if the one we have is actually the policy, or if it were actually the policy, it covers the truck and its equipment. And the jack and the compressor are equipment. It doesn't have to be, according to Mr. Saldana, doesn't have to be equipment purchased at the time the vehicle is purchased, new. But if it's equipment used in the truck, it's covered. They didn't do anything with that claim. They didn't deny it. They didn't pay it. They didn't, and there's no excuse for it. No one ever said, oh, well, we thought this, or we thought maybe it wasn't truck equipment, or anything. It was just completely ignored, and is ignored today, by the way. I mean, they still haven't paid the money for that jack and compressor. So this is not a case of just just the bad things they did with respect to the NADA printout and withholding the fact that they only pay wholesale. It's much more than that. There are multifaceted things that they did to this poor guy, and it caused him extreme distress. He got sued by his title loan company. He got his wages garnished. It damaged his credit reputation. I mean, he went through a lot, and so this is a case where punitive damages were appropriate, and this is not one of those cases where what happens sometimes when juries go crazy and they award enormous amounts of punitive damages. This is a mid-six-figure verdict. It was reasonable. It's within the single-digit multiplier, and the verdict should be the judgment should be affirmed.
Well, the follow-up question.
You had one more. I'm sorry. I rambled on too long.
That's all right, counsel. The question, it had to do with the amount of the punitive damages. You make a reference that's within a single-digit multiplier. It's unclear to me, candidly, what constitutional parameters there are after BMW and in our court, the Hudgens decision. Briefly, can you comment on that? How this verdict can be sustained?
Yes, and I've set forth some cases that involve much higher ratios of punitive damages than this one. We are within the single digit, which our Supreme Court of the United States said is the kind of the outlying limit of what you can what meets muster under the Due Process Clause.
Does that mean a 9-to-1 is constitutionally?
I think so. I mean, and there are other appellate courts have talked about 9-to-1 single digit. That means 9-to-1 is kind of, but even then, there are cases that have come out in the circuit courts, and even the Supreme Court has suggested that's not always the case. And the parameters are you look at the reprehensibility of the conduct that justified the punitive damages, and part of what you look at is the difficulty in assessing and calculating damages for what happened. And we have that exactly here, where the harm to Mr. Preciado in dollar amounts was fairly small. His truck was worth $14,000 and some change, and they wanted to pay him $11,000 and didn't pay him for 2.5 years. But it's not, and so determining the amount of compensatory damages is difficult, and that's one of the factors you should consider. And in cases where that is difficult, or it is small, or even minimal, then a larger ratio is to be done. But one thing that's perfectly clear from the Supreme Court and the decisions from this court on punitive damages and that ratio is it's not supposed to be and cannot be a mathematical bright line formula, and that's exactly what they would like it to be. And the cases
Arnett,
are
with that, I'm going to interrupt you. I appreciate that. I believe you've answered
Yes, thank you.
Judge
Thank you.
Winthrop's question. Mr. Onifree, rebuttal.
Thank you. If the court has any additional time to spend on this issue, I would leave to the court. Mr. Arnett says he didn't misrepresent the testimony. The relevant testimony is at day 2, pages 139 to 146, specifically page 144 is where he would say he elicited it. And then the relevant deposition pages are included in the summary judgment motions. And if you look at pages 116 to 118, I maintain he said actual cash value is what Loya pays, and that turns into Young America pays wholesale. And that's not a fair representation. That was the basis for the punitive damage claim. And if the court does not believe that that evidence was elicited, then that being the basis of the punitive damage claim, it should go away. The consent order, maybe happenstance, but it's referenced in his billing memos as being discovered 11/6, November 6. That motion that ended up in the order that's used in combination with the testimony and consent order is the day after he discovered the consent order. Again, maybe it's serendipity, maybe it's not. But the big problem is you get the consent order and you say, well, Mr. Onifree, it relates to your client. Looking at that paragraph, there is nothing that would, number one, alert us that it relates to total loss valuations, which are not any one of the reference documents, but it's the way he used it. And we're talking about meeting the clear and convincing standard for punitive damages. That is complete speculation to say that that consent order shows that Young America systematically pulled or hid from the Department of Insurance those total loss valuations because they used a wholesale basis. That's complete speculation, and that's how he used it. So even if you say I should have known about it, no way would I know that he would say that that's what it shows, because it doesn't show that. And that's just letting the jury speculate. That shouldn't be allowed generally, and certainly cannot be the basis to sustain a punitive damage claim. Again, if we were given more advance notice of how it was going to be used, we would have then been able to develop the fact that there was an explanation for why those documents were not produced to the Department of Insurance. It would have at least neutralized it. Truly, in closing, what was I going to say? I had no response to his claim. This is what it shows. I mean, as a trial, anybody that's tried a case, I've got the Hobson's choice. I sit there and let him shove it down my throat, or I say to the jury, oh, it doesn't say that, knowing that every juror says, really? Well, why didn't you prove it? They don't know that it just got dumped on us. They just know I didn't prove it. And that's a Hobson's choice. In terms of the additional acts of bad faith that would warrant the punitive damages, every argument that he listed, I don't remember being briefed. That's not what he argued was the basis for the punitive damages outside of his primary theory. There was testimony about that, but that's not what he's saying. In his brief, he talked about deducting the salvage value. 2 times, first 2 offers, no deduction of salvage value. The third one that tendered it without the salvage, we said, we'll give it to you. You just have to sign the power of attorney. Now, when Mr. Arnett says the police notified us because we were the registered owner because he signed the power of attorney, where would that be in the record? We were asking him to sign the power of attorney so we could retain the salvage. That is not an accurate representation of the record. So the 4 items that he argued, separate from that main theory that we say was completely contrived, was deducting the salvage value, which he ultimately got without the deduction, said not providing the documentation. Again, he didn't ask for the documentation, the record. His client, and this is at page 188 of the second or third day of trial testimony, it was the settlement amount that the plaintiff was asking to be given to him, and it had been communicated to him 2 times. The third item, placing full and final settlement on the check. No one attempted to extract any advantage from that, and that came through our office. We certainly knew there was a dispute about the value. And then the claim about not tendering the undisputed amount. Borland suggests, could that be a basis of bad faith? Yes. Not a basis to prove punitive damages. The punitive damage award should be completely vacated, Your Honor. Thank you.
Thank you, counsel. We appreciate your arguments today. We appreciate your briefing. You've given us much to think about. We will take this matter under advisement. We'll issue a written ruling in due course. We stand adjourned.